Good morning, everyone. This is Joe Adams here. I'm a U.S. immigration lawyer based in Los Angeles. And as some of you may already know, I'm this year in 2025 splitting my time between Los Angeles and New York. I think given the extreme challenges and lack of information and complexity of the immigration environment, me being bi-coastal is a something that I really want to do. So right now, I'm coming to you from New York City. I'm going to be splitting my time this year between Los Angeles and New York City. I will probably have an in-person webinar, excuse me, in-person seminar, probably in London, coming up in the spring. I may have one in Mexico City. If there are other places that you'd like me to come to, just drop me an email, let me know. Just based on my own observation of my own client base and the people who seek information from me. Western Europe, London, Latin America seems to be the places where people are coming from. So London and Mexico City probably this year. But if there is another place that you'd like me to come to, let me know and I'll give it a thought. We've got a big presentation today. There are so many questions that people have about the current immigration environment, and I've got my own experiences that I'd like to share with you. Just as a matter of housekeeping, I will record this session. If you're not able to attend the entire session, that's okay. I'll send a recording to everyone, so if you have to drop out early. Also, if you've ever attended any of my webinars in the past, you know the best information comes from your questions. So feel free to drop a question in the Q&A. I promise I will get to everyone. Don't ask anything too case specific or too personal because we don't want to breach any attorney-client privilege or share any matters. I see that there are a number of current and former clients on the Zoom, and there are a lot of new names on the Zoom. So I'm encouraged by the fact that people are trying to get good information about the current immigration landscape in the United States. So let's get into it. So first, if you listen to the news right now, you would think that the Immigration Service is closed for business, that people are foolish to file immigration cases, that there are students at the Columbia University who are getting detained, that there are people who are getting held up at the border and sent home for their political beliefs. The news is scary. The news is frustrating to me as a lifelong civil libertarian who believes in free speech. That's what the news is saying. From my perspective, uh, it's business as usual. If you could get into my brain and talk to the clients who I've been working with over the last few months since Biden left office and Trump has come into office, we've filed visa cases, we've filed green card cases, we filed citizenship cases. Those cases have been processed. There are sometimes bumps in the road during any administration. Sometimes there's a request for further evidence. Sometimes an embassy makes a mistake. But we've been able to get all that cleared up. So from where I'm sitting, if I could take the news out of my brain, as upsetting as the news is, it's been business as usual. Just in the last few weeks, we had an athlete who is a non-binary person who was approved to do their work as an athlete. We had a visual designer whose family comes from sub-Saharan Africa, from Nigeria. Her preliminary green card case, her I-140, was approved. We've had people go through embassies and consulates. In fact, we had a fellow a few weeks ago, a Sikh fellow, the who wears a long beard, who wears a turban. Maybe someone who might suffer from some anti-black and brown prejudice. Uh, he went for his regular interview at the U.S. Embassy in Delhi. The embassy officer, they basically ran the wrong script in the interview. They ran an F1 student visa script when they should have been running an O1 visa script. We were able to reach out to that fellow's congressman here in the United States. That congressman was a hardcore MAGA Republican who helped us clear up the things at the embassy. And that fellow, who is a Sikh, is now living and working in the United States just as he had been previously. So, so the temptation is to say it's the best of times, it's the worst of times. That's not quite right. It's it's a very unusual time to be practicing immigration law in this time. But as I remind people, in the first Trump term from 2017 to 2020, there was never a time where I held a case. There was never a time where I said, "Hey, let's just wait and see until we get a better, environment." Uh, there was never a time where we said, "Let's just wait to see what the administration does, this, that, and the other." So uh, that's my philosophy going forward now. Despite all the obstacles in the first Trump administration with his weird appointments, with his odd policy proclamations, and then of course that year of COVID. COVID caused a lot of delay and frustration, but mostly due to COVID, not necessarily due to Trump. It was a matter of filing cases, preparing them, seeing what the Immigration Service does with them, and getting people through the embassies and into the states. We can get bad decisions regardless of who's in charge. We can get bad denial decisions, in any era, in Obama and Biden eras or in the Trump era. So, we always have the resource of filing a lawsuit in federal court. In fact, we are preparing to file a new lawsuit right now where a decision that my client and I disagree with, a denial decision, was issued by the Biden administration, and we are teeing up the case to be sued, to sue in federal court. We'll see what the court does with it, but I'm optimistic that the judge will be fair, impartial, neutral. We don't know who our judge will be yet, but when we file our lawsuits in federal court to fix errors. I have had Biden judges, Obama judges. I've even had some George W. Bush judges and Trump judges, and I have found them to a person to be fair, impartial, reasonable, thoughtful. So the message that I want to communicate is, let's try to take the temperature down. Let's try to remove some of the hysteria and fear. One thing that's come up a lot lately with my clients is, though they've been reaching out. They're people who have lots of feelings about the current administration. They have an absolute right, as a free speech absolutist, First Amendment believer since I was a young person learning about these things in high school. You have an absolute right to speak your mind. If you are a human being in this country, in the United States, you have a First Amendment right to speak, to protest, to petition the government for redress of grievances, to assemble peaceably. Of course, you have a right to peaceful assembly, peaceful protest. You don't have a right to riot. You don't have a right to advocate the violent overthrow of the government. You never did, and nor do I. So if people are worried about speaking out against the current administration and their policies, it's up to you. But I am not a believer in compliance in advance. As Timothy Snyder, the famous historian who covers fascism, we do not comply in advance. That's how they win. And I think the current administration, if given their own devices, would have you comply in advance, would have you not speak your mind. That's the whole idea of singling people out. The student at Columbia University, if you follow this in the news, a fellow who was very pro-Palestine, very anti-Israel, said a lot of things that I found to be pretty distasteful, pretty anti-Semitic, used methods that I don't particularly agree with in terms of blocking access to people, and shouting some pretty disagreeable things, not things I agree with. The content doesn't matter. The content is irrelevant unless he was advocating violence, unless he was providing material support, to a terrorist organization. I think a judge looking at these facts will eventually release him and put him back into he's in green card status. So I don't know if you follow that case or not. There's a lot of information out in the ether about people being stopped at airports, uh, uh, their phones being searched. What I remind people is that that's been around for a long time. There's been a long dialogue between civil libertarians and the government about what your Fourth Amendment rights are at the border. So remember, the Fourth Amendment to the U.S. Constitution says that you are protected from the government. The government is not allowed to conduct what we call unreasonable searches and seizures without a warrant. So if a police officer wants to come into your home and search your home, you can consent to that. I don't recommend that you ever consent to that. Otherwise, the police officer has to go get a warrant, has to go to a judge and say, I have probable cause, reasonable suspicion that there's evidence of a crime in the home. Judge, will you give me a warrant to search the home? And they have to prove it to a judge. At the border, there's been a long-standing string of Supreme Court cases that have been around for almost 100 years that say at a border, our Fourth Amendment rights are diminished. And can they look through your phone? Yes. Can they look through your luggage? Yes. For people who are in the United States or attempting to come into the United States on ESTA or on a tourist status, something that's very discretionary, just play it out in your head. You're planning to come into the United States. They say, sir, can we unlock your phone? Please enter your password. If the answer is no, which is you're right, they'll probably say, okay, we're turning you around and sending you home. You unlock the phone, they can search through things. One thing that I am seeing more and more of is a reality that people may be attempting to work in the United States without realizing that they are working. So the US immigration laws haven't been updated since the early 1990s. Part of the subject of the book I wrote last year, Extraordinary Aliens, was covering the history of the legislation behind the categories that create the O1 and EB1 category visa and green card statuses. And in that research, I realized U.S. immigration law is very difficult to change. It hasn't changed since the early 1990s, but everything else in the world has changed. This conversation, for instance, couldn't have taken place. A lawyer's office would have been, filled with rows and rows of books and librarians and assistants, and now all of that is digitized and a subscription service that I access. Think of all that's changed. What hasn't changed is U.S. immigration law. And so what's been happening is people will come to the U.S. with a plan to continue doing their job, continue doing their work from home, but do it in the U.S. Maybe they want to escape the cold British winter. They want to live in L.A. or live in New York and see some shows and go to some places and things like that. And while they're here, they plan to work. Well, that's not allowed. And where I have been seeing problems lately is people trying to enter the U.S. who have a plan to perform services, even if they're going to be paid in Mexican pesos or euros or British pounds, even if they're going to be paid in a foreign currency into a foreign bank, they're planning to perform services, and that's what's causing a problem. I'm seeing it a lot with musicians, with social media influencers, and even now with some executives. So, one thing that I really want to communicate to this audience, and this would be true if we're talking about President Kamala Harris or we're talking about President Donald Trump, is Customs and Border Patrol is very keen on this fact that attempting to enter on ESTA or B1, B2 tourist status isn't work authorized. And if your plan is to continue being, a bank executive, an entrepreneur, a working musician, even if you're not being paid in US dollars, the plan, the issue is you could be seen as working. And what's the consequence there? It can get really dicey really quickly. What happens in real life, you go to the box, you go to Customs and Border Patrol at the airport, or if you're entering through the land crossings at the vehicle station. They'll say, "What are you here to do?" "I'm here to go to Disneyland. I'm here to take my kids to a Broadway show." And then they say, "Can we look through your phone?" Answer yes. They look through your phone and they see that you've got some appointments lined up. They see that you've got a performance lined up. They see that you've got a plan to have a meeting with your U.S. colleagues, and that could quickly turn into, "Oh, sir, you're planning to work." What happens next? It kind of depends on how nice the officers are. Best case scenario, they turn you around and send you home. They cancel your B1, B2 visa. You're permanently ineligible for ESTA if you're from an ESTA country. And now you have to apply for a formal visa. Also, what might happen, a little worse, you might get slapped with a 5-year ban on entry. You were considered an intending immigrant, you didn't have a work visa, and you plan to come to the US to work. 5-year ban. There's a waiver called what's called a HANCRA waiver. We prepare them all the time. They're discretionary. Uh, we have to file for the regular working visa, which for most artists and entertainers is an L1 category visa. And then if that's approved, then we have to apply for a HANCRA waiver, which is discretionary. The embassy official might just say, "You haven't spent enough time in serving your penance. It hasn't been long enough. You were slapped with a 5-year ban on entry. Come back in a few years." So let's avoid that. And then finally, the worst case scenario where they say, "Look, not only did you plan to work, you lied, you misrepresented, you said you were coming to bring your kids to Disneyland, but you had a secret plan to work. You made a material misrepresentation. You are banned for life from ever entering the United States." And again, there are waivers. HANCRA waivers might be a possibility, but my goodness, let's not get into that situation if we can avoid it. I have a question from the audience. Let me answer it live. How difficult is it for an Irish musician to get into America? Well, let me take that one step at a time. The fact that you are Irish is not a relevant factor. That most visas are not tied to a specific country of origin. There are a few. The E2, excuse me, the E3 visa is specifically for Australians. George W. Bush wanted to thank Australia for participating in the Iraq War, gave Australia a special visa for technical workers, similar to the H-1B visa. There are certain visas created by treaty in Singapore, in Malaysia. But for most people who are looking to move to the United States to work as a musician, I would typically first look at either the O category visas for extraordinary ability, or I'd look at the P category visas for performing groups. It would sort of depend on, is it just you or is it your performing group, and what are you planning to do? How difficult is it? Both the O visa and the P visa are what we refer to as petition-based applications, meaning we submit a detailed written petition to a government processing office here in the United States. The government office reviews the case under the relevant criteria. So, say for instance, with an O1 visa, they're looking to see that the person has a very high level of ability, as demonstrated by their past achievements, their credits, press, awards, letters of recommendation from experts in the field, evidence of good pay. These are subjective criteria. Then, if the officer is satisfied that you have a high level of ability, they also want to see your itinerary of upcoming US-based events that cover a period of time. So, for instance, if you are a multi-award winning, Grammy award winning musician who has nothing upcoming in the US, that's not a case I'd file, because that's not a case that should be approved. What I would typically say for a musician, what are you planning to do? Are you planning to create a new album? Are you planning to tour something? Are you planning to do press and publicity or touring related to something that's already been released? When it comes to the itinerary for an O1 visa, one common mistake is people will, especially musicians, will focus on the live performance dates. They'll say, "Well, I've got a gig at the Roxy on the Sunset Strip. I've got a gig at a club in Vegas. I've got a few dates in New York City." But it's everything that leads up to and follows those performances. It's negotiating with the tour company. It's negotiating the deals and doing the rehearsals with the backup acts and creating new work for the live performances. Also, a common mistake, there's no requirement to show that you have to do the work in the United States. If Harry Styles wants to record his new album at a studio in London, or he wants to record it at Capitol Records in Hollywood, it doesn't matter. The government doesn't say, well, why do you have to do that in California? Can't you do that in London? That's not a query, but sometimes people will assume that that is a requirement. Another question that comes up from time to time, and this is a myth and a misunderstanding, but it comes up so much I want to mention it. There's this idea out in the world that you have to prove that an American can't do your job. Just think about that rationally for a second. How would we ever prove that the 330 million Americans that live in this country can't do your job? And certainly there are many artists, entertainers, musicians, STEM professionals, entrepreneurs. Can they do your job? Maybe. There's a notion in a green card category called an EB2 and an EB3, where the sponsoring employer must attempt to recruit an existing US citizen or an existing green card holder for the job, market the position at a reasonable manner for a reasonable time at a market rate salary. And after that reasonable period of time has elapsed, and a cooling off period has elapsed, then the employer certifies to the U.S. Department of Labor that there weren't any qualified U.S. citizen or existing green card holding applicants. That's all that is. That's what's called the labor condition application in EB2 or EB3 cases. Sometimes people call this the PERM process, the permanent labor certification process. It is not relevant to O1 visas, not relevant to EB1 green cards. So for a lot of my clients who are highly talented, we avoid that whole process. But I always want to mention the fact that there is at no point do we have to prove that there were no qualified Americans or that you were the only person who could do your job. It comes up with enough frequency that I always want to mention it. Another thing that comes up very frequently in the world of O1 visas, remember, O1 visas are for a very high talented individual, a person of extraordinary ability in the language of the regulations. That's why I called my book Extraordinary Aliens. Okay. I focused on people who get the O1 Extraordinary Ability Visa and the EB1 Extraordinary Ability Green Card. With an O1 visa, it's not tied necessarily to a traditional job offer the way, say, an H-1B technical worker visa is or an L-1 intra-company transfer visa is. An O-1 appreciates the fact that talented people might work for multiple different employers unrelated to one another at the same time. Think of it like this. Imagine that you are a celebrity hairstylist. You work on the cover of Vogue, on the major runway shows. You have a celebrity clientele. You are a high profile celebrity hairstylist. You might have 40 different people or publications or organizations that you work with in a given period of time, say over the course of 3 years. In the old days, pre-1991, that would have required 40 separate filing fees, 40 separate applications, 40 separate immigration officers reviewing your case. That was a mess. So the innovation was to separate the concept of who the petitioner or sponsor is from who the actual employer is. So what we can do is we can bundle those 40 different job offers under a single petition and nominate a U.S. company or a U.S. person to be the petitioner or sponsor for the visa. Since 1991, the Immigration Service has clarified, as recently as 2011, in a policy memorandum, clarifying that as long as we have a U.S. company or person nominated by the individual beneficiary, the foreign national, and also those employers, say those 40 clients of the hairstylist, uh, that U.S. company or person can be the petitioner for the case. The petitioner agrees to sign off on the case that everything's true so far as they know, and the petitioner agrees to accept official documents on behalf of the case. Other than that, there really is no further requirement. Sometimes people make an assumption that the petitioner or sponsor of an O1 visa is something like the sponsor of a family-based case. In a family-based petition, like say you're a U.S. citizen sponsoring your foreign national spouse, the requirements are much more extreme. There's a financial commitment. There's a commitment that you're in a bona fide relationship called a marriage, a bona fide familial relationship. With O1 visas, it's much more minimal. So when people will sometimes call me up and say, "Hey, Joe, I've got job offers lined up. I've got a great background. I think I can hit the mark, but I just don't have a sponsor." We can usually resolve that very easily. I have a guy right now, he's on his third O1 visa, pretty high profile actor. His US citizen uncle, who has no affiliation with the entertainment industry, has always been his sponsor. Great, it works for him. Why is this important? In the world of O1 visas, there's a very helpful provision that says for an artist or entertainer, the petitioner, the sponsor of the visa, may add additional performances or engagements, contracts during the validity period of the visa without filing an amended petition. In other words, say you've got that hairstylist case again, 40 different job offers lined up. We file the case, we get it approved. Now, for the 41st person wants to hire the hairstylist. Well, how do we do that? The petitioner just needs to agree to it. There's no new filing that we have to do with the Immigration Service, because if there was, think about it, for every new job, for the fashion model, the photographer, the hairstylist, for the television director, we'd have to go through a new immigration process. That'd be very cumbersome. So selecting your petitioner is a very important thing, and it's so simple that I think people overcomplicate it. Also, we see the word agent in the regulations, and I want to just kind of give a side note on that. If you look up the regulations, you see that the petition may be filed by an agent. Okay. What is an agent? Well, if you're in arts and entertainment, you naturally think it's like a CAA or a WME, someone who procures work in exchange for a commission. That is what I would call an entertainment agent. In the context of the regulations, an O1 agent merely just needs to be someone appointed by you and the employers to file the case. So, for instance, that actor whose US citizen uncle is his appointed agent. He's not procuring work for the fellow. He's not charging a commission. He's doing a favor for his nephew. He's a US citizen. He signs off on the paperwork. Everything's true. He agrees to accept official documents on behalf of the case, which come to me as well as the lawyer in the case. And all of that, of course, is disclosed and truthful. There's nothing to hide. We're not, this isn't a loophole. We're going through the front door here. So that's how the sponsor works for O1 visas. And then to contrast that, when a person is ready to become a permanent resident of the United States, many times U.S. U.S. citizens will sponsor their spouses, but say you aren't in a family relationship. Say you want to self-petition. The government allows for the extraordinary ability green card, the EB1 green card, to self-petition. It's one of the few times in U.S. immigration where you can self-petition. So for EB1s, there is no employer, there is no family member. You are your own sponsor for EB1, and there's no labor certification as well. So it's a really streamlined kind of system. Not fast, not without its issues. None of this is fast. None of this is as fast as I'd like it to be, but it is faster than getting a labor certification and dealing with an employer. Another question. Let me answer this live. I've been married to an American for 20 years now. I became a legal U.S. citizen 10 years after. If ICE hears my Oh, I'm sorry. I'm having. Oh. If ICE hears my foreign accent while I'm in the street, can immigration stop me in the street as bad faith if I'm not carrying my U.S. passport or proof of citizenship? I heard ICE is targeting people without allowing them to talk to a lawyer or family member. This is an excellent question, and I'm really glad you asked it. So it sounds like you've been doing everything the right way. You're a U.S. citizen, a naturalized U.S. citizen is the same as me, a natural born US citizen. We are equals. There is I the law there is no law that says speaking in an accent is probable cause or reasonable suspicion to think that you've committed a crime. You have a Fourth Amendment right to protect you from unreasonable searches and seizures. You're walking down the street and you're speaking in Spanish or Tagalog or Russian, or you're speaking English with an accent. That is not probable cause or reasonable suspicion that you've committed a crime. If a police officer comes up to you, an ICE agent, police officer, whoever comes up and stops you and says, "Hey, papers, please," it is your absolute right to say, "No, I am not giving you my papers. You have no obligation to carry your papers. I don't carry my papers. I'm a U.S. citizen, just the same as you are. I have a birth certificate somewhere. I have my U.S. passport, but I don't carry it with me." So they have a right to know your name to see if there's a warrant out for you. You have an absolute right to speak however you want. Here's what you do. If you are stopped, the first thing you say is, "Am I free to go? Am I being detained? Am I in custody?" And you just say, and they say they might lie to you. They might bullshit you. Uh, ICE officers, police officers, they are allowed to lie. They are allowed to try to trick you. They will try to make you feel like, hey, let's just make this easy on everyone. And they're known to do this. Don't give into it. Be tough. And in fact, you can find online, maybe I'll send some resources where people will practice these scripts, ICE officer stops you, Mr. Lopez, may I, what's your name? Fabricio Lopez. Okay. Mr. Lopez, what's your immigration status? I'm not talking to you. Mr. Lopez, let's just make it really easy. Just show me your passport. Show me some documentation. I'm not required to do that. Uh, then you say, "I will only speak to you with my lawyer," and that shuts down the conversation. Lawyer. The first thing you say is lawyer. If you don't have a lawyer, reach out, find one. If you do have a lawyer, call them up. Now, that many times though, just you being tough will make them go away. They're not looking for people who know their rights. They're looking for easy targets, right? They just want to get their numbers up. Remember, ICE officers and police officers are workers, just like a lot of workers. They're trying to meet quotas. They're trying to make their ratios good. They're not looking for a tough time. They're not looking to do paperwork. So you get stopped, you say, "I'm not talking to you." You have a Fifth Amendment right against self-incrimination, and asserting your Fifth Amendment right, it can never be used against you. I don't know if you've seen, there's a show called Adolescence on Netflix right now. Excellent, excellent show set in the United Kingdom. There's a scene early on. I'm not giving anything away. It's excellent. I wish you would watch it. But in the UK, the system there is if you don't agree to give an interview, that fact that you've refused to give the interview could be used against you. In the States, the Fifth Amendment says, "I refuse to talk to you. I assert my Fifth Amendment right. I am not talking to you. I will only speak to you through a lawyer." And that shuts down the conversation. Now they might try to trick you. "We're going to make this easy for you. You want this to be easy? You want this to be hard?" Dig in your heels. That being said, that being said, if it was me, you know, I'm a white guy with an American accent, and if I get I haven't been st I haven't had a police interaction in a long time. If it was me, someone were to stop me, I'd probably just say, "F off. Here's my California driver's license. Leave me alone." It's up to you, but but those are what your rights are. Your right is to speak to an attorney. Your right is to not to talk to the government unless you want to. Okay. Um, we're kind of in uncharted territory. One of the things I wanted to mention as well uh, is the fact that um, we have this administration that is so aggressive and that is pushing the boundaries and I think crossing the boundaries of the law. And what has happened as a result? Khalil, the student at Columbia University, the civil society has rallied around this person. It's in the news, it's in the courts. Volunteer lawyers are working with the guy. That's the response that I would have expected. And so no one's taking this lying down. This is not a papers, please kind of country. It never has been. Let me see. There's a few more questions. Okay. I think this is the same fellow from before. Thank you, Joe. Some questions. As a green card holder, do I need to carry the card everywhere I go? Can I be stopped at customs? We have a question looking through your phone. What else do we expect at customs? Also possible to naturalize and get a passport before the 3-year mark? If so, how long does it take? Okay, let me just take these in turns. The technical rule is that you're supposed to carry your green card everywhere you go. I do not like that rule. And it's just a practical matter because if you misplace your green card, unlike, I left my American Express at a restaurant the other day. They FedEx me a replacement 2 days later. Easy, didn't cost me anything. Replacing a lost green card is a pain in the ass. It's hundreds of dollars. It's months of time. I, if it was me, I probably wouldn't carry it everywhere. But the technical, real answer is you're supposed to carry it with you everywhere, just in your wallet. Can I be stopped at customs and be questioned? Yes. Can they look through my phone? They can ask anyone to open their phones. One thing that we lawyers are very worried about is, and remember, the phones thing, that's an Obama era policy. So this has been around for a while, and we've had these concerns for 10 years plus. Uh, you know, what we worry about as lawyers is my laptop, my phone is filled with attorney-client privilege information. If you're a therapist, your phone, your computer is filled with patient-client privileged information. So what I would do is flag to the officer, there might be attorney-client privilege material in here, there might be patient-client privilege material in here. Um, and then again, there's the practicality of it. Advocating the violent overthrow of the government is not free speech. Advocating uh, 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 crimes, planning a crime is not free speech. So what do you do? I'm not sure what I would do. If the next time I come through the border, if someone says, I want to open your phone, I would probably say, I'm a lawyer. I have a lot of attorney-client privilege information on my phone. I'm not amenable to this. Let's talk to the supervisor. Let's get legal involved. And then that means I'm spending the afternoon, not doing whatever I had planned to do, but dealing with that. I'm also thinking maybe I just get like I have like an old cell phone with nothing on it. Maybe I just use that when I'm traveling. That's not a bad idea. I think as a practical matter, yeah, you could open my phone and there's nothing on it. Um, and then, is it possible to naturalize and get a passport before the 3-year mark? So the rule is that 90 days before. So let me back up. So when a person cannot jump from out of status or no status or visa status directly to citizenship. He or she must always become a green card holder first. They get their permanent residency, they get their green card. If their green card's based on marriage, 3 years, pretty much everyone else, 5 years. 90 days before the 3-year mark or 90 days before the 5-year mark, you could file your green card, your citizenship paperwork, and they're actually processing them very quickly right now. I've filed probably 5 or 6 naturalization applications in the last few months, and those cases are going through very quickly. I hope it stays like that. I wish I could tell you that all case types were processing quickly. Some case types are processing very slowly right now. Do you have any? Let me answer this one. Uh, do you have any knowledge of how they search your phone? They do it, they call it what's called a cursory search, where they can look through the text messages, they can look through the emails, they can look through your social media. They can also, on their own, look through any publicly facing social media. So if there's something on your social media that you think could be a problem, perhaps get rid of it. Do they search for keywords, work-related, political? I don't know. Do they look at your photos? I had a case in the Biden years, and this is a story, so give me a moment. I had a case, terrible case in the Biden years. I had a woman who had been in the US for many years on an O-1 visa. Her life had changed and she decided to move back home to her home country. She had a tourist visa, an ESTA. She's from an ESTA country, and she's coming back and forth to see her U.S. citizen boyfriend. I think he was based here in New York. So she's traveling back and forth between Europe and the United States every few weeks to see her U.S. citizen boyfriend and disclosing that truthfully to the Immigration Service. The Immigration Service here at JFK unlocked her. Can you unlock your phone, please? They unlocked her phone. They looked through her photos. There was a photo of her bare chested, which she had sent her boyfriend, which is a, not prohibited thing. The officers there acted like a bunch of schoolboys, showing this image to other people, other male officers. They really gave her they made her feel like she was a prostitute, which of course she isn't. Sharing intimate photos with your long distance partner is not the, I don't have any issue with that. And it's certainly not an immigration issue. Um, so we filed a formal complaint with Customs and Border Protection. They canceled her ESTA, which was unfortunate because ESTA travel is so simple. So they canceled her ESTA, and then she applied for her formal B1, B2 visa at the embassy, and then that was issued. And I'm very glad that we filed that formal complaint because if we hadn't, whatever the Customs and Border Protection people had written in their report was going to be the last word on it. So we corrected the record with that. Anytime that you interact with a Customs and Border Protection agent, an ICE agent, a police officer, if you say anything affirmatively, you must always, always be truthful. You cannot lie. If you lie, we are going down a very dark pathway very quickly. Uh, at the same time, they might lie. They might make up something. They might mischaracterize something. What happens is when you have those kinds of interactions at CBP, you're put into a special room. They'll usually have like a Q&A, and then they'll commit that Q&A into writing. It looks like a screenplay or a script, question, answer. And then right as they're about to release you, they'll have you review it and sign it, review in inverted commas and sign it. In this particular case, they said, here, sign this paper and your flight's in 3 minutes and you got to go. So she signed it without reading it, which, okay, I understand. And it contained factual errors, it contained inaccuracies. So in our complaint to CBP, we talked about the really boorish and immature and unprofessional behavior of the officers with respect to this photograph. And also, we corrected the record as to what was actually said. If you have a negative interaction with CBP, the best thing you can do immediately is write down as best as you can remember who the officers were, if you know their badge numbers, write down as best as you can remember the questions and the answers. As far as we know, there's no audio recording, video recording. There's no court reporter writing things down. So their notes are going to be the best evidence of what happened unless you have your own notes. And then, of course, talk to an immigration lawyer straight away and talk about what we can do next. Okay, that's the best I can do. What do they look for? It's a mess. If you travel with your spouse, can they search their phone related to your entry or vice versa? Well, yeah, anyone who's entering, regardless of who they are. Um, let's see. I just recently, let me get this question going. I have recently just had a baby, so a U.S. citizen. I know that doesn't mean much for O1s and O3s because the baby is of no legal use for immigration status until they're 21. Yeah, and I'll flesh that out for people who don't know what that means. But surely there is a crossover between legal obligation of a parent who might be in and out of immigration status with U.S. born citizen. For policy reasons, which I tend to agree with, uh, a U.S. citizen child may not sponsor their foreign national parents for green card status until the child turns 21. Yeah, it would be a perverse incentive for an infant with a guardian or a guardian ad litem, if we're going to use the legal jargon, to sponsor their parent. It would create some really perverse incentives. So a U.S. any human being who's born in the United States under the 14th Amendment to the U.S. Constitution, they are automatically a U.S. citizen. That's why I'm a U.S. citizen. That's why my parents and grandparents are U.S. citizens. They were born in the United States. No further inquiry required. No inquiry as to the parents' immigration status. Okay, this is one of these Trump executive orders, which has already been shot down in multiple courts. There's no mechanism in the 14th Amendment to inquire as to the parent's immigration status. If a human being is born in the United States, the birth is the citizenship, okay, in the territory of the United States. Um, Now the other part of the question is if say I'm just going to assume for purposes of this conversation that you are say undocumented. That say you came into the United States as a tourist and never left, or maybe you came into the U.S. on an O1 visa and never left. Uh, when can your U.S. citizen child sponsor your green card at age 21? So, if you said you recently had a baby, so it's not going to be for a long time. There are probably other routes to get you into a normalized status. That's something that I'd like to chat with you about one-on-one. So just drop me an email and we'll set up a time to chat one-on-one. All right, Javier. Javier, the next time I enter the US with my B2 visa, hopefully soon with my O1 visa, should I revise everything that I've written with friends or family or publish in social media on my phone? Should I erase anything that can create problems for me in customs? If that's your call, I am, like Timothy Snyder, the historian says, I am not a believer in compliance in advance. If you want to write fuck Trump and fuck Pence and fuck Elon Musk, I'm all for it. I think I wear my political beliefs on my sleeve and I don't hold them back. And that is your right as a human being, regardless of your immigration status, in the United States. If you want to play it safer, I understand. I'm not going to fault you for it. All right. Let's see. Thank you for this Zoom, Joe. What rights do a conditional permanent resident have at the border? My wife obtained her spousal visa January of 24, so about a year ago, and her green card shortly after arriving in the US in March of 24. In a few weeks, she'll be traveling back to her family's home in Brazil for a 3-week stay, and we're nervous about what happened when she comes back to the US, layover in Chicago and out to US. So yeah, so she'll enter the US in Chicago as an international arrival on a green card and then she'll fly domestically Chicago to LA. A conditional permanent resident, for those of you who don't know, a conditional permanent resident is a permanent resident. So let me define some terminology. A lawful permanent resident, an LPR, is a person who has a green card. Those are the same thing. The term green card is just a slang term. It refers to the old color of the cardstock that they used. I guess in the 1930s, green colored ink was hard to reproduce, so they used green. And the immigration inspector in the 30s and 40s would show up at the mine or the factory, and they'd say show the green cards, and everyone would raise their green cards when there are a lot of foreign workers. And so green ink was hard to forge, probably why our dollars are green. Green ink was hard to manufacture. Uh, as a leftover, the plastic credit card size card is still printed with green design on it, but it is a card that has your biometrics on the magnetic strip. It has a lot of anti-fraud features. It has your photograph, your date of birth. It has a lot of identification information. I think it even has a digital copy of your face in the magnetic strip. So even though they're not green pieces of paper, they are plastic cards the size of a credit card, and we still call them green cards. So just as a matter of terminology. Us immigration lawyers will sometimes call green card holders LPRs, lawful permanent residents. Okay. Now, what is a conditional permanent resident? A conditional permanent resident is a permanent resident that has a condition attached. The condition is this: what this person has told me is that they were in a marriage that was less than 2 years old when they filed for the green card. So your wife filed for her green card, and your marriage was less than 2 years old. She gets a green card, but it has a string attached. The string is at the end of 2 years, the couple files a joint statement saying we're still together, everything's copacetic. The immigration office has the option of calling you back in for a second interview. It's very unusual for that to actually happen. If you're the U.S. citizen, if you were to pass away, if you were to commit domestic violence against your wife, or the relationship just doesn't work out, your wife would need to file for a waiver of the joint filing requirement. Even though this is unpleasant, I always want to mention this because I have met far too many people who didn't know about this and thought, my U.S. citizen spouse died, my U.S. citizen spouse and I are divorced because we just couldn't make it work, or there was domestic violence and I stayed in the relationship. I always want people to know that there is the waiver option. So your wife is a green card holder just like any other green card holder. So she has the same rights and responsibilities and obligations as any other green card holder. The conditional nature of it doesn't change my thought process. In a few weeks, she's going to be traveling back. Again, I think it's just the same general advice, general guidelines that I've been giving the whole time. It's up to you. I don't comply. I don't want to comply in advance. If you have things that are anti-Trump, anti this administration, as long as you're not advocating the violent overthrow of the government, it is permissible free speech. Question. When looking at a green card holder's social media, can CBP look into your account if it's private, not public? So CBP has broad discretion to exclude people who pose a danger to themselves or to others. I assume that they have access to anything that's public. So if you publicize something, if it's something that's on a public facing Facebook, Instagram, Twitter account, etc., I assume that it's available to them. Can they get into your private materials? I just don't know. Now, from their own computer screens, no. You know, can they unlock? Can they ask you to unlock your phone and go through your Finsta, for which is a term I had to learn, your Finsta, your private friends only Instagram? I don't know. I wish I knew. They are not being transparent about these activities. But then again, it's up to you. If you're not saying anything illegal, I don't have a reason to say that you should change things. But again, this is your appetite for risk. This is your immigration. So it's up to you. We're coming up on the 1 hour mark. If anyone has any final questions, all these questions have been fantastic. I really appreciate the interest in this topic. I know there is a lot of confusion out there. I'll send a recording to everyone who's signed up. Feel free to pass along this recording to anyone who you think could benefit in your community. I think the best thing we can do in these tough times is get good information out there, not succumb to fear, not succumb to intimidation, and as you know, not succumm to compliance in advance. This is a rule of law country until it's not. This is a liberal democracy until it's not, and I'll be damned if I'm not going to do my best to make it the best country we can make it. Henry, we'll finish on this one. We'll wrap up on this one. Henry, this is a very good question. Has there ever been a time where immigration has ever been this worrying? Yes. It's been a lot worse in history. First of all, first of all, um, uh, we had a system of chattel slavery in this country up until 1865. We had something called the Chinese Exclusion Act in the 1920s, where if you were a Chinese person, you could not immigrate to the United States. There were strict racial quotas up until the Immigration and Nationality Act of 1965. If you were just from certain countries, mostly in Asia and Africa, you just couldn't come. When at the top of the conversation, uh, I said how most countries. Someone said I'm an Irish musician. Can I? How does this work? These immigration rules are country neutral. I've had Iraqi clients. I've had Afghanistan clients. I've never had a North Korean. They're not really allowed to leave. But it's the same country. It's the same process, regardless of the country you're from. Not so in our history. And so it was very tough. In my own family, in our own immigration history, we had a lot of Italian and Czech immigrants who were treated terribly, not allowed to have certain jobs. This is more in society, less in terms of the rules. Not allowed to have certain jobs, not allowed to live in certain parts of the community, beaten up, extorted by the mob. That's just in my own family history. One more question, and then I'm going to have to wrap up. Okay. I have a dear friend actress who could not join this Zoom. She's Venezuelan. Her O1 visa expires in July. If for any reason she gets stopped in the street because of her Latino looks or accent, can they deport her or cancel her visa, arguing she's part of the Biden asylum program shut down for Haiti, Venezuela, or Cuba? Okay, so your friend is in the United States on an O1 visa. I would want her to be filing her new O1 visa case to extend her status as soon as possible. Um, we've got some time here. It's only April 2nd. So I would want her to be filing the new case soon. And then once the case is filed, she's allowed to remain in the US. She's not accruing unlawful presence. If she gets stopped for whatever reason, she's got a no-one visa. You know, uh, uh, for context, for the people who don't know, there is a separate program, a humanitarian program, which was created in the 1991 bill called TPS, Temporary Protected Status. So when there was that giant earthquake in Haiti and then the assassination of the Haitian president, we declared TPS status, temporary protected status for Haitians. Venezuela is going through a terrible time with its economy and then its political upheavals. President Biden declared TPS status for Venezuelans. After Vladimir Putin invaded Ukraine, President Biden declared TPS status for Ukrainians. Those are for people who are in the U.S. When a tragedy occurs. It's not a way to immigrate. Okay, if you happen to be a Venezuelan, happen to be a Haitian, happen to be a Ukrainian in the U.S., say when the war broke out, you can get a work permit. And for as long as the TPS status continues while the country is dealing with its humanitarian crisis. Now, one thing, for better or worse, it's the president who makes this decision. They can declare and undeclare TPS status. So it sounds like your friend, though, isn't on TPS status. She's on O1 status. So they there's no basis for them to say that she was in the U.S. on TPS status. If you have Venezuelan friends who are in the U.S. on TPS status, we need to figure out a solution for them ASAP. I don't know why Trump has had such an axe to grind against Venezuelans. Venezuela has had a hell of a time as a country. They're wonderful people. I have so many Venezuelan friends who left because of the terrible climate in the country. And uh, I just, it just seems inhumane to me. Um, uh, yeah, you're going to share the recording, but yeah, please feel free to share the recording. Um, to apply for dual citizenship Italian for minors in New York, is state authorization required or is parental consent sufficient? I don't know the answer to that question. A person can be a dual Italian U.S. citizen. When it comes to minors, if there's an issue with the other parent, if say there's been a divorce, that gets a little outside of my area. So I'm going to wrap it up here. We're at 1 o'clock. I'll send a recording to everyone. If you've got any follow-up questions, feel free to drop me an email. We'll set up a time to chat one-on-one. Again, thank you so much for all the interest in today's session. Feel free to share this with your communities and stay safe and good luck.